Won't the voice just be a lawyer's picnic and lead to lots of High Court challenges?
No, and Andrew's just quoted one of Australia's most eminent constitutional lawyers, Brett Walker, who's actually used the word nonsense to describe this very suggestion. Of course, anything in the Constitution can be argued in the High Court of Australia, and many of the provisions of the Constitution have been argued in the High Court of Australia since the High Court was brought into existence by the Parliament in 1903. Not in 1901. Here's a little example for you. The Constitution says we need to have a High Court, but it left up to the Parliament to work out what the High Court was going to look like, how many judges there would be. Initially we had 3, now we have 7, because the Parliament over time has altered the form of the High Court. So too for this voice. The third paragraph, which we had up on the screen a moment ago, makes it crystal clear that it is for the Parliament to determine what the voice will look like, what its powers and functions are going to be. Full stop. It's going to be up to the Parliament. And it's a very sensible provision because it's quite likely that if this referendum succeeds, and I very sincerely hope it will, the Parliament in the months that follow the referendum will work out what form the voice will take. But in 20 years' time, it might be that we're a much bigger country. Maybe we'll be a smaller country. I think it's more likely we're going to be a bigger country. It might be that our population distribution has altered. A whole lot of circumstances about Australian life may have altered, and the Parliament may think that it's appropriate that the form of the voice that has been arrived at in 2024 isn't appropriate in 2044. And it's absolutely right that the Constitution should give that power to the Parliament to decide from time to time what the voice should look like. So, no, it's not going to be a lawyer's picnic. Ken Hayne, a High Court judge, a retired High Court judge who's helped us in this process, made a different and somewhat more complicated comment in saying it's nonsensical to assume that the High Court would ever find an implication in the Australian Constitution that would gum up government or would make for endless litigation. And there's lots of examples one can point to of the High Court doing the exact opposite of that in making practical decisions about what the Constitution means, in making practical decisions that ensure that government continues to work. People who are predicting this lawyer's picnic proposition are assuming that the reverse of that. And Ken Hayne, Brett Walker, and a whole host of other constitutional lawyers have said that's wrong.